SJC-10941, Commonwealth versus Cruz.
Good morning, counsel.
Good morning, Judge. Your Honors. Raymond Busso for Juan Cruz. I was wrong. When I did the brief in this case, I focused on the issue of excusable neglect, of manifest necessity, of really contesting what Judge Welch did in ordering the mistrial. And what I missed, and the mistake that I realized that I made over the last week in preparing for the argument, is his whole ruling is based on the idea that not turning over the discovery involved was sloppiness. And it's
As
not...
opposed to intentional misconduct? Is that
It
what you mean?
is intentional or so egregious in the form of preparation that it really does get to that. Sloppiness is different. If I agree to mow your lawn or paint your house and I start to mow the lawn and I leave parts undone and don't trim it or clean up, that's sloppiness. If I go to paint your room and kind of do a patchy job and leave drips all over the place, that's sloppiness. But if I don't mow your lawn, if I just say I'm going to mow your lawn or paint your room and I don't do it, I don't make any effort to do it, that is not sloppiness. That's neglect. That's intentional in that you made an agreement to do something and you haven't done it. And when Judge Welch said that a simple order that says, provide a copy of any computer-generated information obtained by the police during the investigation, if it still exists, the prosecutor amended, and you don't make a single call, you don't pick up and make a copy of that and send it to the police officer, and over the course of 3 years, despite your agreement, despite the court order, you just don't do it, and you say, I saw the box of notebooks with 500 to 1,000 pages of relevant discovery that I agreed to provide, and I don't make any effort until the third day of trial to disclose it. That is not sloppiness. That is the type of neglect. That is the type of indifference in which innocent people get sent to jail for a long time. That is exactly why we have discovery orders and why the government is bound.
So how does that change your argument here? Are you saying that because this was so neglectful that essentially the Commonwealth caused the mistrial?
Yeah, it should have been dismissed.
And they have not met their burden
Yes.
that it was necessary.
The right thing to do at that point was not mistrial, was to dismiss it. This is such an egregious error.
Well, even if you don't go there, I thought one of your arguments was, accepting for the minute that sloppiness and negligence are sufficiently similar that you don't get into intentional misconduct, that there were other alternatives. Well, I guess I had two questions. One, are you arguing that, I think you are, that waiver of, that waiver was a definite possibility here? Your client had waived, that was worth exploring, and that should have been the end of it. Isn't that part of what you're arguing?
That is, in fact,
And
the bulk of the brief.
are you abandoning
No,
that?
I'm not abandoning it. I'm trying to supplement it because I feel I missed this. I didn't realize, I guess, enough of how much of the judge's decision in declaring the mistrial is based on that idea of sloppiness. So I'm happy to deal with that, and I think the law is pretty clear on that you can waive rights to complete a jury trial if it is a reasoned and reasonable strategic decision that you make.
Well, is it really a waiver, or is it simply that you would demonstrate that it was not ineffective assistance to say, I wish to go forward in view of all the circumstances?
I don't know. I wish I could say I'd thought about that, whether it's really a waiver or is it just a reasoned decision. It was clearly a trial strategy decision.
Okay, well, clearly you do not believe, you did not believe at trial that you would have been ineffective for going forward.
No.
So you made a determination strategically that the better course for your client would be to go forward as opposed to having a mistrial.
Correct. And spent a great deal of time before the morning of the third day talking to him about the options. He was actively involved, although he's Spanish speaking, with the trial of the case, which had gone close to 3.5 years before getting there, and knew the chances, or at least my best judgment, about what his chances were going into the trial. And as the trial unfolded, bit by bit, he was kept apprised of what his chances were. And that jury, with the way that prosecutor presented the witness, both of our feelings were that his chances of success went up significantly by the way the evidence went in. And one of the reasons for asking that there be no mistrial is because those errors can be corrected.
In Commonwealth versus Perkins, which I should have looked at a little more carefully, but I guess I thought that there was a determination that you can waive conflict-free counsel. I mean, insofar as there's some conflict here.
I think that's clear that you can. You can waive rights that you're guaranteed by the Constitution so that you're not imprisoned by those rights, whether it's the right to have 6 people for a jury or 5, it can be waived. Can you waive the conflict of potential issues with your counsel? Certainly you can.
But you can't waive all conflicts. I mean, there certainly is precedent that suggests that that a waiver might be so distortive of the process that a judge can reject it. The Wheat case, the U.S. Supreme Court case, certainly suggests that there's at least at the margin some ability to say, no, that's all very interesting, but that would not serve justice in this courtroom, and I'm not going to permit that waiver. Why can't the judge say the same here? No, this is so important that I'm not going to permit the waiver because I don't think this would lead to a just or fair result.
Then that's declining to accept that counsel and a defendant can make a reasoned choice about strategy. And I'm not saying that all rights can be waived, but when you get 90% of
whether they can be waived, but the question is whether the judge has the authority to say, yes, generally, but not here, because the outcome, because justice would not be done. And above all, I have an obligation to ensure at the end of the day that justice is done in this courtroom.
I agree with you that that's the ultimate decision. And I guess it's part of the reason why I say it should have been dismissed.
What would the rule be if you prevail here? What's the rule going forward?
Judge, I've heard you ask some pretty good questions at the mock trial competitions in the last few years. I don't know what the rule's going to be. That's for you guys to make. But I know in this case, this should have been disclosed. It is done by a prosecutor who agreed to provide it, and it wasn't the typical 1-page or 2-page or 10 pages or a police report. It was a Xerox box full of 2 notebooks and over.
Well, I'm just wondering, does that mean that the more creative a defense attorney can be in terms of requests for discovery, the more it puts a burden on the Commonwealth to comply, and then if they don't comply, that's a basis for court action?
Well, I don't think it's the creativity of the defense counsel. This was a several-month investigation that clearly indicated there was stuff going on. So for any reasonable counsel, and I'm not the best trial lawyer, although I sometimes think I am, around, but I know what to go looking for. And this would have helped me create a timeline with other suspects, and for that reason, it would have been helpful.
There wasn't much dispute that this was supposed to have been turned over and wasn't.
I'm sorry,
There
what?
wasn't really serious dispute that this should have been turned over and wasn't.
No.
So, I mean, there wasn't any request for, reconsideration by the Commonwealth. So you've got this stuff. And you initially present to the judge that you cannot go forward. And so what you're suggesting is you can change your mind after making a convincing argument to the judge that it would be bad practice on your part to press this case without this. You switch gears. And now you say, no, I want to do this. And so the judge then has before him or her an option, which ineffective, which strategy. Can the judge choose? You presented two scenarios,
But
or
not
not,
at the
or is
same
it your
time.
choice? That's what
Not
you're
at the
saying.
same. I requested dismissal. I specifically did not ask mistrial because I'd spoken to Mr. Cruz. Mr. Cruz did not want to do this again. He liked the jury. He liked the way it went in. His odds were better. So I only asked for dismissal. And as soon as the court made clear it was even asking for mistrial, quite frankly, it caught me
Well, you objected.
a lot.
Yes.
Let's assume it had turned out differently. Let's assume you had, let's assume that you had said, well, as you did, I don't want a mistrial. The judge says, okay, we'll try the case, and your client loses. Do you lose the right then to argue that the counsel was ineffective for having made that choice?
Does my client lose that? I don't know. I guess it would depend in part on the inquiry that the judge made at that time about the basis of the decision.
Let's assume he did everything you said to do. He did a colloquy with your client. You provided a full and complete record as to the reason for your decision to proceed. But it turns out later on that new counsel probably looks at those records and says there was substantial exculpatory information there that would have potentially made a difference in the trial. Do you lose your right then to appeal?
I think
on
you
that
do.
basis?
I think you do the same way as if you waive the right to have 6 people decide your case and decide to go with the 5 based on your feelings, input on the strategy. You don't get a mulligan at that point.
But there's a difference with a jury in that here there is evidence which is arguably demonstrable that says the evidence would have turned out very differently. Not that we don't know whether 5 versus 6 would have made a difference, but you arguably could be able to show that there was enough in those 500 pages that they would have made a difference.
I agree that it's a conundrum, but I think you waive it. A waiver is a waiver. Now, if I'm wrong, and Justice Scorti suggests it's not really a waiver, it's just an informed decision, I don't know.
So often in trials when there is late produced discovery, the solution is to give somebody time.
Yeah.
But given the argument that you were making, didn't the judge feel foreclosed from that as an alternative? That there's just no way it's going to take me weeks and weeks and weeks to go through this box?
Well, he certainly didn't take very much time before denying the motion to dismiss and declaring a mistrial. Now,
Was the suggestion ever raised, though, by anyone, including you?
we didn't really
That,
explore,
That,
nor was
give
there
me
time.
a couple of days, give me the long
Right.
weekend, give
Right.
me...
It was not, because my motion was a motion to dismiss at that point. I didn't want the mistrial, but had we gone on to an argument, at least now in retrospect, clearly I would have said, give me 24 or 48 hours, let me go through this, let me see if I need other orders, or if there's something else that can be done by way of an instruction to the jury.
You indicated you were willing to go, I read it as you were saying, since he was offering the mistrial, and you said, no, I am, as Justice Duffy said, I'm switching my position, given where you're coming from,
Right.
and I want to go forward. So you might have explored, but the chances are you were going to go forward right then. And your point is, your client knew that, and he was going to have to live with the consequences.
Yes, and always, in retrospect, I think we can look back and say I could have done a better job. Had I had another half an hour at that point to say, okay, if we're going forward, how quickly can I get these documents? Can I then have a continuance till tomorrow to just go through? Might I need to recall witnesses or call other witnesses? It might have required some fine-tuning, but that was my client's decisions. That was my strategic decision. That's what we wanted.
This may seem a funny question, but what day of the week was this?
Wednesday.
It was a Wednesday, so there was no chance for the weekend to be, you mean you could have, obviously, but it wasn't a Friday.
Well, it's a Newburyport jury, so they're not real busy a lot of the time.
Is it unthinkable that when you're asking for a dismissal, that the judge is going to instead say, no, a mistrial?
No, it wasn't
I mean,
unthinkable.
wasn't that something to anticipate?
Yes, but trial counsel, in the middle of the end of the trial, we were 90% of the way through the trial. I'm gearing up for both a closing argument and huge amount of discovery, dealing with the motion to dismiss overnight. So had I been the team that defended some other group, with multiple lawyers, it might have been better done. But I did not anticipate perhaps what I could have a year later in terms of this.
Counsel, thank you very much.
Thank you.
Your time is up.
Good morning. May it please the Court. David O'Sullivan for the Commonwealth. I would suggest that the narrow issue before the Court is whether the judge acted within his discretion in declaring a mistrial, where he rested his finding of a manifest necessity expressly on defense counsel's own representations about the volume, potential exculpatory significance, and the length of time he would need to assimilate the material that had not been properly disclosed in advance of trial.
But the defense counsel changed his tune, if you will, in the middle of that discussion. So why would we focus on that, since the defense counsel at the time was saying, if you're offering me a mistrial, I don't want it. I want to go forward.
Right, but the judge can't, the defendant can't back away from his representation that it will take me 3 months and significant time and help to even begin to assimilate this material, and it's
Well, why can't he if he says, I'm not going to do it? If my alternatives are mistrial or that, mistrial or nothing, I'm going with nothing. Why can't he do that?
Because the judge has an independent interest here in ensuring a fair trial for the defendant, and he has an independent interest in the rendition of just verdicts, and that the proceedings in his courtroom appear to be fair to all who view them, and he has an independent interest in ensuring that any conviction that would result from this trial is free from serious questions about the adequacy of the waiver the defendant would have to make in order to go forward that day, given defense counsel's representations. And they're worthy of repeating. This is in the hearing.
We read it.
This I am incapable, right, even of processing. It would take me 3 months because there are so many things I just don't understand.
Counsel, in a vacuum, if that's his presentation, those are his druthers, right? But then, given the alternative, there's another strategy. That's what he's arguing. The strategy is, I've just looked at the case. The Commonwealth had 3 days. It's lousy going in. We have a good shot, 70%. I'm going to stand on it. Best shot. My client wants this. Why deprive a client of that, a defendant of that, if that's the defendant's choice?
Well, any strategic choice that rests on a prediction of how the outcome of a trial is certainly a chancy business. The judge appeared to disagree with the defendant's assessment of his chances of an acquittal, and any conviction that would result from this would be definitely suspect, given defense counsel's own representations about the volume and significance of this material.
What if there had been an inquiry of the defendant, as defense counsel was asking, and the defendant indicated, yes, I know all that, I know about the 3 months, et cetera, but no, I want to go forward.
Because if any conviction resulted, the defendant would be emphasizing exactly those statements which I just began to read,
Yes.
which he now wishes to
And the court would say,
de-emphasize.
you've waived it, wouldn't it?
Well, the judge, as in the case of conflict-free counsel, needs discretion in his ability to accept or reject that kind of waiver.
But conflict-free counsel raises other issues, doesn't it? I
Yeah.
mean, that's sort of about the, I mean, I really think the Wheat case is a different scenario.
It's a different, it is a different factual scenario, but it's the same in the sense that the judge, or the court discusses the independent interest of any court in the rendition of just verdicts. And that's what the judge had in mind and what underlied his decision in this case. Of course, the defendant has a valued right to, once a jury has been chosen, to continue with that chosen jury to verdict. But that case, as the Supreme Court said in Wade v. Hunter as early as 1949, that interest, valued though it is, and the judge did not give it short shrift in this case, must be subordinated in some cases to the public interest in fair trials designed to end in just verdicts.
How do you square your argument with the fact that a defendant has the right to proceed pro se, even though the Supreme Court has said since Gideon that that person is not likely to be competent to represent himself?
Well, that's true. And when a defendant waives his right to counsel and elects to go on his own, that trial is fair in the sense that the defendant's, honoring the defendant's autonomy requires that the court honor his choice to go it alone. The defendant here didn't do that. He elected for the assistance of counsel. He cites to no case, nor could the Commonwealth find one, in which when a defendant elects to have the assistance of counsel, he can then waive counsel's essential effectiveness and waive what is essentially his right to a fair trial. The judge certainly has discretion in a circumstance such as this, given defense counsel's earlier representations about the volume and significance of the material and the time he would need to assimilate it, to reject any proffered waiver. So
you're saying that a client has the autonomy to proceed by himself, proceed pro se, even though the court has said in Gideon that makes it unlikely he'll get a fair trial, but once he chooses counsel, he loses the autonomy to say, I'm prepared to take the risk of counsel being deemed ineffective?
in this case, yes. In this case, in this particular circumstance, yes. Not in every circumstance.
Because why?
Because of, again, the volume and significance of the material. What defense counsel, he elected...
We don't, I mean, nobody at the time had, it's an argument. We don't have any idea that it's, there's definitely, it's true, it's voluminous. But we don't know that it has any significance whatsoever.
Well, this is what the person in the best position to inform the court about that is the defense counsel.
And then the defense counsel says, if the options are changing, it isn't that important. It's more important that we go forward.
But he never backed off his earlier representation that it would take, his earlier factual representation that it would take me 3 months to assimilate this material. And the judge, another point, the judge expressly offered him a continuance. And
When did
he
the judge
said
do
no.
that?
He
When
said-
did the judge do that?
He did, in the course of the hearing in which the mistrial was granted, he said, I take it, given your position on this, that a continuance would have to be too long. And defense counsel said, yes, it would have to be too long. Any continuance is not, would not be a viable alternative in this case, given what he'd already said about how long it would take him.
Well, I guess what I'm not really understanding is how you could determine whether or not this was significant material without having a chance to look at it, at least to make an initial determination as to whether it's significant. And then I'm not sure, what about the connection between the significance, the potential significance of this information and the degree of culpability of the Commonwealth in not having turned it over sooner, and how the judge could have made a determination of sloppiness without first, rather than intentional misconduct, without having first had some analysis of what the material itself was.
The defendant, the defendant did make a cursory examination, a half-an-hour examination of the material, and it's his representations that the judge relied on. And I think that was perfectly proper for him to do. The judge and the Commonwealth are not in the best position to determine what the defendant's perspective is exculpatory. He said, the defense counsel, after reviewing the material for about a half hour, that some of it appears to be very helpful to the defense that was thus far presented. That is, use of the search situs, use and occupancy of the search situs by other people. So the defendant's assessment of this stuff is it appeared to be very helpful, but he would need 3 months to go through it and help in order to properly use it. With respect to the second point you made, which is how does the intentional or non-intentional nature of the non-disclosure fit into this case? The defendant argues for the first time that this was intentional conduct, which was intended to goad the Commonwealth or the judge into declaring a mistrial.
He didn't argue that below?
He didn't argue that below, and what the judge's finding, which I would suggest is reviewed on a clearly erroneous standard and is well supported by the record, was that this was not intentional, although it was a very significant discovery lapse. What happened was, and what the judge's findings reflect, which are well supported, is that the box in question was made available to the defendant on numerous occasions, both when he traveled to the police station in order to view the trash pulls. It was brought out at that time, but though it was not, the defense counsel's attention was not specifically ever directed toward it. And it was brought to court on the numerous dates for the motion to suppress, but again, defense counsel's attention was not drawn to it.
Is there any indication that the ADA had ever looked in that box?
The ADA had looked in the box. That's not in the record, but had done so. And ultimately, what the discovery order required was that that the Commonwealth make copies of computer-generated materials and provide those to the defendant. Ultimately, the judge held and ruled that this was not intentional conduct. It was sloppiness on the part of the Commonwealth, which perhaps was attributable to too much work on the prosecutor's plate.
Let me just, so you're saying that the ADA had looked at it, the order was to make copies, and no copies were made. Is that right?
That's correct. Yeah, there was no dispute that there was a discovery violation in this case. But what's before the court now, particularly because we're under 211.3, is specifically the declaration of the mistrial and whether this was within the judge's discretion. Now, as long as that determination is entitled to appellate deference, as long as three things happened. First, the defendant was given a full opportunity to be heard in opposition to the mistrial, which he was.
I think it's the reasonable alternatives piece of that triad that's important here.
Certainly, and the third being the fairness, whether the judge gave reasoned consideration to alternatives and reasoned consideration to issues of fairness. Now, the continuance was rejected expressly by the defendant. The waiver, I would suggest that was within the judge's discretion to reject that also, where he rested his determination again on the defense counsel's own representations about the material, which he could not then back away from, essentially. Either it takes you 3 months to assimilate this stuff, or it doesn't.
Well, but you could back away from the fact that you need to do that at all in your assessment of whether it's more important to go forward right now than to have any opportunity to review those materials.
I would disagree in the sense that any backing off from that would have to rest on a review of the materials. It couldn't.
So the alternative could have been to give the counsel a day to look at the materials and then decide whether or not to have a hearing in which he took what the defense counsel had to say and what the defendant had to say into consideration. It doesn't sound like the judge considered that an alternative at all.
That alternative was presented to the defense counsel and was rejected by defense counsel.
What, to have a little bit of time to take another look at it and then come back in and see if their client wanted to waive?
Well, he had already reviewed it for a half an hour, made written representations and oral representation about the specific contents and about their significance and about how long it would take him to do it, how long it would take him to assimilate it, and was there a specific statement that, or a specific option like, let me give you to the end of the week, 2 days, defense counsel rejected any continuance as an alternative in this case. And
Was that conversation about continuances while he was, before the judge said, I'm not going to grant a mistrial?
It was, yeah, it was prior to the declaration of a mistrial. So
Well, he didn't. I mean that he wasn't. I'm sorry, he wasn't going to dismiss it. Was it before that?
It was after the initial motion was a motion to dismiss a
Right.
discovery sanction.
Right.
In connection with that, the judge discussed the possibility of a mistrial, and then he declared the mistrial following his denial of the motion to dismiss as a discovery sanction.
So the conversations about the conversation about, I take it that no short continuance would work, and defense counsel said right, was before he said, I'm not going to dismiss this case. Is that right?
It was before. It was after that, and before
After he said, I'm not
declared-
going to dismiss it?
After he said, I'm not going to dismiss it, after he found that the discovery lapse was unintentional, alternatives to a mistrial were discussed, including a waiver, including a short continuance or any continuance prior to the declaration of the mistrial. Now, the two reasons, or the three reasons that I see my time is up unless there are further questions. I'd rest on my brief. Thank you.
Thank you, sir.